Welcome everybody to tonight's lecture. Can I start by acknowledging the traditional owners of the land on which this court is situated, the Turrbal and Yagara people, and I pay my respects to their elders past, present and emerging. I also wish to acknowledge that the topic tonight, juvenile justice, is a topic that impacts Indigenous Australians in a disproportionate way, both in relation to arrest and incarceration. The flyer for tonight's lecture highlights the plight of two boys who in 1897 had been remanded in custody in a local watch house for stealing a pigeon. It was noted back then the punishment, even if guilty, must have been greater than many a woman beater or hardened thief suffers. If the system is to blame, it is high time that it was recast on a more merciful basis. 2 weeks ago in Townsville, I sentenced a boy, an Indigenous boy, who'd committed more serious crimes than stealing a pigeon, but he was 15. He'd spent 455 days on remand. He'd spent 10 days of that in a watch house. He spent 185 days in lockdown, in detention, with less than an hour out of his cell. And that was not because of behaviour, that was because of staff shortages. There were other shorter periods of lockdown, and all in all, he had 24 days of normal routine. So this is the rehabilitation we're currently giving to the children in the Cleveland Detention Centre. Our speaker tonight will speak to the historical development of the law of juvenile justice. Dr. Robyn Blewer is a lecturer at Griffith Law School. She specialises in criminal trial procedure and vulnerable witness testimony. She completed a Master of Criminology and Criminal Justice in 2012, and her doctoral research focused on Australia's child witness law as part of the prosecution project. In 2019, Robyn became director of the Griffith University Innocent Project. She also teaches criminal law courses and has experience in commercial litigation and volunteering with the Salvo's Legal Humanitarian. I asked her why there was such a short biography here. She tells me she's just collecting qualifications. She's being very modest because I did Google her, and that Google shows that she's written a plethora of articles, particularly on the law in relation to child witnesses. She's also written on this subject before in 2017. And she has spoken widely in relation to the Griffith University Innocence Project. So she's much, much more than that very short biography I've given you. When we think about the subject of the development of youth justice or juvenile justice, it seems that the focus originally was on moving towards the treatment of children differently to adults, recognising that they often were victims of criminal offending themselves and very often severe neglect. The pendulum seems to be swinging back to a punitive approach where the differences between children and adults become much more blurred. Dr. Blewer, in her lecture tonight, will explore the development of the law in this area, culminating in today's adult crime, adult time laws. I'll ask you to put your hands together for Dr. Blewer.
Thank you, Judge, for that introduction. Before I begin, I just want to say that my slides tonight are really intended to be decorative. and to give people a reason to look anywhere else but at me. If you can't see them or you can't read them, then that's not going to be a problem. I'd like to echo Her Honour's acknowledgement of the traditional custodians and pay my respects to all our First Peoples. This presentation contains content that may cause some distress or sadness. It includes brief descriptions of violence and references to people who have died. I'd like to thank the committee for this invitation, and I'd like to also thank my colleagues from the Harry Gentle Resource Centre for their help, support and encouragement in preparing this presentation. Thanks to Joe from the Supreme Court Library, and also to Dr. Lisa Durnian for all of your help as well. And thank you all for being here in person or online. I am going to begin by repeating that press report about 2 boys being remanded in custody in a watch house. The article said, as you just heard, they were detained in one of the cells, and there they remained, and they cried throughout the whole morning and intermittently through the afternoon and night. Given the contemporary landscape of juvenile justice, I expect many of you may have wondered when this incident occurred. Yesterday, last year, last decade, last century. Indeed, it was the 19th century, and it was 1897 to be precise. The 2 boys were, as you heard, awaiting their trial for stealing a pigeon. The author of this piece, printed in Perth's Daily News, continued, "The punishment, even if guilty, and according to British law they are innocent yet, must have been greater than many a woman beater or hardened thief suffers. If the system is to blame, it is high time that it was recast on a more merciful basis." Tonight I'm going to be exploring the law's response to the youth crime crisis of the late 19th and early 20th centuries. I have 2 caveats at the outset. First, juvenile justice, as we know, is moving quickly daily at the moment. I don't have the time or scope here to cover all of the relevant issues. I note, though, just this morning the news about a drop in New South Wales in convictions related to children under 14 due to the application of Dolly Incapacts. This is a fascinating issue, but I'm not able to cover it this evening. And second, I am presenting tonight as more of a historian than a lawyer. I am adopting a methodology as explained by Canadian criminal justice historian Professor Emeritus Douglas Hay in 1984. It's a lengthy explanation, but when I embarked on a history PhD as a lawyer, this approach helped me conceptualise the differences in what I had been trained to do in law with what I was doing in my PhD with the prosecution project, and I hope it does the same for you. Hay writes, "For many historians with no particular expertise in the matter, the doctrines of the law rather resemble an impressive range of mountains. The law mountains are said, by those who claim to know, profoundly to affect the intellectual climate of an age. The frontier between state and civil society apparently runs somewhere along the line of their peaks. One of the recognised professional duties of historians is to track every movement of a tiny group of very important people. We watch in astonishment from the ground as our subjects make their way up one or another commanding height of law. But for most historians, that is about as close as we get. We do not know much about the mountains, even less how to climb them ourselves. Occasionally, one of us will try to track the route of one of those lawyer mountaineers. It quickly becomes apparent that even a short walk in the law mountains may require an intense, if improvised, course in technique. And to get to the objective quickly, the imperative for all legal climbers, one cannot linger en route to ponder the origin of the range or to wonder at curious rock formations and admire the goats. But that is what the historian will want to do, understand the origins of the mountains, their stratification, the forces that shaped them, and, incidentally, to admire the goats. If practicing lawyers are competitive climbers at heart, most historians are contemplative geologists. As a contemplative geologist, then, I want to explore a moment in the history of juvenile justice in Australia, focusing on the forces that shaped it in the late 19th and early 20th centuries. I'm not offering any solutions to any of the contemporary challenges our criminal justice system is facing. Rather, I hope that this next hour or so gives you some insight into the apparently perpetual and unnervingly consistent debates over juvenile justice. I will discuss how state legislatures, courts, and communities collaborated to bring to life a vision of courts for children. Such courts, though, as we all know, were not a panacea for the problem of juvenile delinquency. From the start, there were compromises, and a good portion of our children, namely our First Nations children, were largely excluded. I will finish then with a brief look at a case from 1922 to discuss the treatment of a young Indigenous boy, the issue of adult time for adult crime, and the intersection of case law, legislation, and public calls for reform. Concern for children or juveniles hasn't always been a given. It was really only in the early to mid-19th century that childhood was deemed something qualitatively different to adulthood, something to be protected, when society collectively agreed that we want children to have a happy childhood precisely because it is a period in everyone's lives when they are vulnerable, in need of protection, love, and affection that will set them on the right path to adulthood. While not framed as a right for children, as we may think of these matters today, there was a growing consciousness that more needed to be done to protect this part of a person's life. It is around this time that we start to see growing calls for something to be done about juvenile crime. Two examples of such calls include an article appearing in the Tasmanian newspaper in 1836, referring to the problem of juvenile crime. Quote, "There are thousands of children who are turned loose every day into the streets to forage for themselves, many whose parents are unable to maintain them, and others who are unwilling." And in 1842, a letter was published in the New South Wales Examiner from William Augustus Miles, the police commissioner and police magistrate of the colony, to Lord John Russell, an English politician, later Prime Minister, who was involved at the time in reforming the English prison system to improve the conditions for juveniles. But for some of the language in the letter, it might well have been written yesterday. Miles said, "I have the honour to address your lordship upon a subject of public interest, if not of national importance, and concerning which no effective remedy has been hitherto proposed, while the present system only tends to increase, not diminish, the evil. I mean juvenile delinquency. I have not followed the opinions of persons who have superficially examined the subject in order to obtain notoriety, but I have, at various times, examined many hundred boy thieves. And it is from close observation of the human mind, influenced by uncontrollable circumstances, that I have arrived at my conclusions. My observations upon the subject of juvenile crime induce me to attribute it chiefly to the following causes. 1, the congregating of the poorest classes in the low neighbourhoods. 2, the neglect of parents. And 3, the facilities of selling every sort of stolen property. We now have decades of research demonstrating that the Police Commissioner's observations were correct. He went on to say, "A very great proportion of juvenile thieves in large towns are thieves from necessity. There are herds of homeless, friendless, masterless boys who have no means of support, who never knew the value of character or the sweets of labour, and who must either rob or starve." How the law should respond to juvenile offenders has occupied legislatures, courts and families and communities for centuries now. In 1850, New South Wales passed an Act for the more speedy trial and punishment of juvenile offenders, providing for the summary trial of children under 14 years of age who had been charged with larceny offences. Victoria's Neglected and Criminal Children's Act of 1864, South Australia's Juvenile Offenders Act of 1872, and Tasmania's Act for the More Effectual Punishment of Juvenile Offenders in 1875 were all drafted in similar terms, focusing on remand and punishment of juveniles. With this emerging interest in juvenile crime came the problem of defining who a child would be for the purposes of the law. Early on, the vague label "a child of tender years" was adopted by the common law in the 18th century and is seen in case law right through to the 20th century. Such a term effectively gave judges a broad discretion in determining whether a young person appearing before them as a defendant, witness, or complainant was a child or not. Legislation provides a somewhat more complex picture. At one point, we had 6 jurisdictions defining child in 5 different ways. Those under 16, as in South Australia, those between 5 and 16 years of age in New South Wales, boys under 16 and girls under 18 for Tasmania, those under 17 in Queensland and Victoria, and under 18 in Western Australia. Irrespective of these differences in defining the child, during the 19th century, distinguishing children and childhood from adults and adulthood led to the development of a separate system of juvenile justice in the United Kingdom, the United States, and Australia. Reformatories and industrial schools became the preferred means of accommodating children and young people who were neglected, destitute, or delinquent. This practice of placing such children in orphanages, industrial homes, and other institutions was criticised even back in the 19th century. 2 reports of the New South Wales Royal Commission into Public Charities in the colony, published in 1873 and 1874, described such institutions as, quote, legalised gateways to hell. The Commission made 2 observations that go some way to explaining the subsequent calls for a new approach to juvenile justice and child welfare. First, that using large charitable institutions for the maintenance of destitute or delinquent children was, quote, unsound in principle and pernicious in results. And second, that the barracks-style design of these institutions prioritised ease for management while overlooking the probable harmful effects on children. The Commission said, the one fatal and all-sufficient objection to the massing of children together under the necessary conditions of barrack life is its utter variance from the family system, recognised by nature in the constitution of human society as the best fitted for the training of the young. At this time, there was widespread belief that the criminal justice system itself contributed to the criminality of children. An editorial in Victoria's Geelong Advertiser in 1906 argued that the practice of charging and trying children under existing systems could have a lasting effect on them, quote, when the exercise of a little common sense and a little humanity would have made him a useful citizen, end quote. Moving the second reading of Queensland's Children's Court Bill in October 1907, the Honourable Peter Airy told Parliament the legal system was, quote, far back in the ages of barbarism. It is curious of judge-made law, he said, that it tends to manufacture criminals. It may well have been politically expedient for a politician to make this observation, but as we know, legislative reforms can be just as, if not more, responsible for criminalising children. So I want to make a brief detour here through the Law Mountains and turn back for a moment to mention an example of a simple legislative reform intended to simplify criminal procedure, which had a significant impact on the criminalisation of children in England. As you'll see, the reform likely impacted on the colony here. When we consider the impact of contemporary reforms to, for example, bail procedure or weapons legislation, this example is a stark reminder of how the law can isolate and impact children. In 1826, the UK Parliament passed extensive reforms to its criminal procedure. The Criminal Law Act of 1826 abolished the distinction between felonies and misdemeanours. This, in turn, had the effect of making orchard robberies, essentially apple stealing, a felony. On the 29th of September 1826, the Chronicle in the UK published a list of juveniles recently convicted of this offence, along with their age and sentence. This list was subsequently reprinted in several Australian publications. W. Field, 11, death. J. Goodwin, 12, death. J. Norris, 11, death. J. Jones, 12, death. A. Smith, 11, death. J. Connolly, 13, death. And J. Grant, 12, death. All were respited for transportation for life. The observation was made in the article that, quote, the Apple Stealing Felony Act will add wonderfully to the population of Botany Bay. A magistrate remarked that he had himself violated this act 500 times in his youth. If the act had passed in his early days, half his friends and he would have been transported. Back here in Australia, towards the end of the 19th century, the notion that the law manufactured criminals, and thus it was the system that needed reforming as much as delinquent children, was the impetus behind several informal attempts at reforming court processes. South Australia, widely recognised as a pioneer of children's courts, used ministerial orders that permitted children to be tried separately from adults. A press report on this new procedure, published in 1891, some 4 years before their children's court legislation was passed, said, "These offences have to be dealt with by law, but it need not put on its most terrifying and sinister aspect. The state manufactures more criminals year by its convict system and penal treatment than it knows of. The removing of even the erring little folks from this atmosphere of crime to be dealt with by a common sense tribunal is a departure from ancient custom on which Adelaide is to be congratulated." In regional New South Wales, Cobar held that state's first informal children's court on the 15th of December 1902, some 3 years before its first children's court legislation was enacted. The local Cobar magistrates, convinced that existing processes were ineffective where children were concerned, had obtained the Attorney-General's permission to hold a, quote, children's court that would allow children to be tried separately to adults. In Victoria, the Attorney-General sent a circular to all police magistrates, empowering them to deal with children's matters separately to adults. There were increasing calls for a move away from a punishment-driven approach to juvenile justice to a more merciful one that would acknowledge the status of the child and look to the future of the country as one of well-adjusted, productive adults. Today we might characterise this as a shift from a justice approach to a welfare approach to juvenile justice. Such a change did not come easily though. Frank Horrocks, a 17-year-old boy and the son of a prominent civil servant in Brisbane, was sentenced to death in 1892 following his conviction for murder. There appears to have been some outcry, at first over the death sentence and then this refusal by Parliament to commute the sentence to life. Responding to the so-called lady remonstrants, who were calling on Parliament to be merciful in this case, Sir Samuel Griffiths said, quote, "If the youth Horrocks were not hanged, it would simply mean that no youth under 18 years of age could be executed for murder." Frank Horrocks was hanged 3 days later at Boggo Road on the morning of 26 September 1892. His well-known father collected his body and Frank was buried at South Brisbane Cemetery within an hour of his death. Perhaps because of cases like Frank's and many others, the informal reforms to existing procedure were ultimately rejected on the basis that, as noted by lawyer and academic Jennifer Anderson, they lacked a firm legal foundation. By the end of the 19th century, reformers were calling for the formal establishment of specialist courts that would focus on character development and rehabilitation of delinquent children rather than on punishment. Campaigners continued to argue that juvenile offenders were often a product of an unhealthy home life, and this had contributed to their criminal behaviour, which in turn necessitated a more merciful approach from the law. These calls came from a variety of sources, including charities, philanthropists, politicians, and legal professionals. Women, however, made particularly significant contributions to the establishment of children's courts. In Victoria, the Attorney-General, the Honourable John Davies, informed Parliament that he had been visited by, quote, a number of ladies to ask him to bring in a bill to make better provision for the trial of children. Queensland's parliamentarians also recognised the contribution that women voters had made to the establishment of the Children's Court here. The National Council of Women of Queensland advised Parliament that no less than 25 women's organisations had examined the draft Children's Court Bill and provided feedback on it. Mr George Ryland, the member for Gympie, declared to Parliament his belief, quote, that the sentiment of women in politics will have a good effect upon our legislation in a good many other things besides children's courts. And I did write this before our federal election on Saturday. Irrespective of who they were or where they came from, children's court campaigners across the country shared similar concerns and criticisms of existing court procedures. They were united in their vision for a modern 20th century juvenile justice system. The central argument was that a mature, progressive society would recognise that children were different to adults. Addressing Queensland's Parliament in 1907, the Honourable Peter Airy said, quote, it really seems absurd that we have gone on for all these years treating offences of children and those which are practically criminal in the same court. To which an honourable gentleman replied, we are not civilised yet. In 1895, the colony of South Australia passed legislation creating its first children's court, and one of the first in the world, and was followed by the remaining Australian states a decade later, between 1905 and 1907, when Western Australia and Queensland established their children's courts. These acts heralded the beginning of a new approach to juvenile justice that was unashamedly intended to be for the good of the nation, not just the children. There were numerous objectives for this new court, but in the interest of time, I'll address a few. We know today that given the right environment, most people age out of criminal behaviour. But even back in the early 20th century, this was acknowledged in the desire to ensure as many children and young people as possible could be afforded the protection of the Children's Court to, in turn, protect them from the stigma of a criminal record. Debating the Queensland Children's Court Bill in Parliament, Attorney-General Blair reminded members that a key objective of the legislation was obviating the need for children to carry the burden of a criminal history through to their adulthood. Definitions of child included in early children's court legislation required children to be, quote, apparently the requisite age to appear before the court. This provision had a strong procedural justification. Many children would not have had the proof of their birth. Allowing children who were apparently the requisite age avoided the need for hearsay evidence of children or others who might only be able to give evidence of age by reference to what they had been told. In addition to maximising the numbers of children who might avoid any negative impact of a juvenile criminal record, ensuring that as many children as possible could benefit from being separated from adult offenders was also vital. Earlier reforms that had merely aimed to reduce the time children spent in custody with adults were insufficient in campaigners' eyes. Instead, they called for the physical separation of children from adult offenders in court, police stations, and elsewhere when in custody. Even though separate hearings were a central concern for campaigners, the statutes reflected the reality that separation might not always be feasible. All jurisdictions would go on to require the physical separation of juvenile offenders from adult offenders in varying degrees. Children awaiting trial could only be remanded in prison where alternative arrangements, such as taking them to a shelter, could not be made. Trials were to be heard preferably in separate buildings, or at least at separate times to adults. South Australia and Tasmania provided for the suspension of separate hearings in any particular case. Such concessions are evidence of the pragmatic decisions that were made in drafting this legislation. When 17-year-old Frank Horrocks was arrested, quote, crowds of people came flocking to get a glimpse of him being transported by train from Southport to Brisbane. Similar crowds were reported to have gathered to watch the hearse leave Boggo Road after his execution and even followed it to the cemetery. Irrespective of where or when children's matters were to be heard, each state made it mandatory for all children's court hearings to be conducted in closed court. The concept of open justice was a hallmark of common law systems and not one that legislatures had been previously keen to interfere with. The 1850 juvenile offender legislation in New South Wales, for example, was very clear that children would still be tried in open courts. It was not until 1890 that South Australia first began closing courts for children's matters. At this time, concern for the welfare of children, the desire to protect them from any negative publicity or attention that an open court might attract, defeated any reservations about the risks of abusive process. In Victoria, the Honourable William Edgar spoke of the harm that was, quote, done to child life when children were brought before the courts today and it was published, for that child was branded as a criminal for the rest of his days. Queensland politicians agreed it was as much in the interests of parents to prohibit publication as it was in the child's interests. The risk that the media had a tendency to make, quote, heroes of child defendants was also used to justify the closure of children's courts to the public. Once again, though, the states differed in how they approached this issue. Victoria's provision was more extensive than others. It made the same general prohibitions as the other states, but went further by empowering police officers to forcibly remove people and issue fines and imprisonment to those failing to vacate the courtroom. Probation officers and mothers, sisters, or female friends of female witnesses under the age of 18 years, or of any female defendant, were permitted to remain in the court. Queensland allowed, quote, the representative of any organisation or institution interested in the care or reform of children to remain in the courtroom. This provision in Queensland is interesting in that closing children's courts is said to have significantly curtailed the work of child welfare organisations by removing a powerful forum for raising awareness of issues associated with child protection and juvenile justice. Queensland explicitly excluded members of the press from attending children's courts, but not necessarily from publishing details of matters heard in them. Some members of the press immediately objected to being shut out of these courtrooms. Only 2 months after the Children's Court Act was passed in 1908, the Brisbane Courier questioned the operation of this provision, arguing that, quote, it is almost impossible for an example to be made of a culprit. The paper reported that Senior Police Magistrate Robert Ranking had been inclined to agree. He wished it to be known that he had recently sent one juvenile offender to the reformatory for 3 years and another to Westbrook Reformatory for 12 months. We wish not so much to punish crime as to prevent it, he said, but this could only be done with stern measures. Ranking's views on the necessity for stern measures were arguably at odds with the vision of a compassionate response to juvenile offenders and raises the question of who would be the right candidates to preside over these courts. Of all the items on the reformers' wish list, this one proved to be the most difficult to satisfy. Various sources suggested the ideal bench would be comprised of members who would be experienced in dealing with children, but not too experienced in criminal justice, because children's matters would be a waste of their time. They should be experienced in crime, but not so experienced that they were hardened to it. The question was fiercely debated in Victoria. Politicians argued that highly qualified and experienced High Court judges should not be bothered with trivial children's matters. Instead, they suggested that the most suitable person might be, quote, a widow of about the age of 50, or, quote, philanthropic ladies. Others thought it preferable to appoint someone who had not been, quote, contaminated in any way through association with criminals, that he should not be hardened by knowing too much about crime. Appointing lower court police magistrates was opposed by members of the community who said such a move would be, quote, radically wrong in that it fails the first essential, that of providing a court competent to understand the child and competent also to inspire confidence in the child. They suggested that police magistrates or honorary justices would lack the requisite specialist knowledge and would not have the time to give children's matters the attention they deserved. Bearing in mind, they continued, that, quote, a mistaken decision in a case of a child may mean all the difference between a life of honourable work and one of crime. South Australia's Minister for Education suggested to that Parliament that power to determine sentences should be given to the State Children's Council rather than justices who, he said, could do more harm than good in sentencing a child of 10 years to 3 years in a reformatory where children might be exposed to, quote, evil influences. In Queensland, calls were made for judges with a special aptitude for successfully dealing with children. Ultimately, no provision was made by any jurisdiction for judicial officers to possess any particular qualifications with respect to children or criminal justice procedure. The appointment of police magistrates and justices of the peace was likely another pragmatic decision that represented another curtailment of the vision for these courts. On the issue of punishment, the priority for campaigners was to reform and rehabilitate rather than punish, as had been the case with earlier juvenile offender legislation. To that end, strategies such as probation and admonition rather than conviction were proposed. This was an area in which the state satisfied the requests of campaigners. Each gave their judicial officers broad discretionary powers to punish offenders as they saw fit. This included powers to admonish the child rather than convict them. And lest I appear to be suggesting that the lawmakers at this time were overly merciful, admonition here, in Queensland at least, seems to have included the use of the birch rod. Other options included committing children to an institution, probation, or fining a child's parents or guardians. This brief account of the introduction of children's courts suggests that the children's courts that were established in the early 20th century did not, for various reasons, match the vision for them. They were arguably compromised from the start. By the time children's courts were introduced in Queensland in 1907, the Aboriginal Protection and Restriction of the Sale of Opium Act had been in place for a decade. Historian David McCallum has previously observed, as have others, Indigenous children only began to appear in the, quote, formerly white children's welfare justice system from the 1960s. I don't have the scope or authority here to begin to discuss First Nations children in the criminal justice system during the protection era in the detail it demands. However, I think it would be remiss of me on this occasion not to acknowledge our First Nations children here. If we are thinking about juvenile justice then and now, the now is the fact that over the 4-year period from June 2020 to June 2024, the rate of First Nations young people aged 10 to 17 in detention on an average night in Queensland increased from 29 to 42 children per 10,000, while the rate of non-Indigenous young people in detention at the same time increased from 1.1 to 1.5 children per 10,000. So, what I'm going to do is finish with a hurried scramble to the peak of the Law Mountains by considering one case that in many ways represents peak law in action. In 1922, a 13-year-old Aboriginal boy was found guilty of one count of murder. The deceased was the wife of his employer. The location was the Biggenden district, southwest of Bundaberg. The circumstances of the case raised doubt, for me at least, about the boy's guilt. No one appears to have questioned why the husband of the deceased did not check his wife's bedroom when he apparently came home from work at 6:30 p.m. and couldn't find her, but found her body there in the bedroom the next morning at 6:30 a.m. By then, though, the young boy had been reported as missing from the property along with an axe and a knife. Like so many young Indigenous boys then and since, he confessed to the offence, and as far as the law was concerned, it was case closed. I note the work of historians who have cited this and other similar cases as examples of Indigenous boys abused and mistreated by their white employers being pushed to their limits and killing as a result. But in this case, I want to at least question this boy's guilt. A newspaper reported that while there was no direct evidence of the boy's involvement in the woman's death, quote, suspicion was at once placed on him. When the child was located the following day after wandering into a bullock driver's campsite seeking food, he is reported to have taken police to a barn on the property where a blood-stained axe was found, and then to a drawer where a knife was found. The boy was subsequently convicted following his alleged confession. He confessed to getting angry with the deceased when she asked him to milk the cows, leading the 5-foot-tall child to, as medical evidence suggested, repeatedly hit his mistress in the face with an axe to the point where she was unrecognisable, and then slitting her throat with a knife, butter knife apparently, cutting it through to the vertebrae. The jury recommended mercy on account of the boy's youth and indigeneity, and appears to have further recommended, quote, children of coloured parentage not be hired out until they were at least 16 years of age. The boy was nevertheless sentenced to imprisonment with hard labour for life. The story, however, doesn't end here. The public defender appealed against the boy's sentence on the ground that it conflicted with Section 24 of the State Children's Act of 1911. Taking into account the various definitions in the Act, the essence of Section 24 was that if any boy or girl under the age of 17 years is found guilty or convicted of any crime or offence punishable by imprisonment, the court, having cognizance of the case, shall not sentence such child to imprisonment. Instead, for such cases, Section 24 provided a list of alternative forms of punishment. Essentially, with this case, what we have here appears to be an adult time for adult crime debate that's over a century old. Queensland's Court of Appeal dismissed the appeal in October 1922. Only weeks prior to the boy's trial, in August 1922, murder had been a capital offence in Queensland for which the boy would have received the death penalty. The majority of the Court of Appeal found that the intent of the legislature in enacting Section 24 of the State Children's Act of 1911 was that it would not extend to a murder conviction because that penalty was death, not imprisonment, and thus the amended Section 305 of the Criminal Code, setting out the punishment for murder, would still apply in this case. The sentence of imprisonment with hard labour for life stood. Justices Lucan and Shand dissented. Justice Lucan referred to Section 24, noting, as a result of Section 24, boys up to the age of 17 years who have been convicted of very serious crimes, the ordinary punishment for which was a liability to imprisonment for life, such as rape or arson, could only be and have only been dealt with under the extraordinarily merciful provisions of Section 24 of the State Children's Act. He went on to note the various acts that had been amended following the enactment of the Act to abolish capital punishment and to amend the Criminal Code and other enactments accordingly. And he said, quote, "I think this is significant. No amendment was made to the State Children's Act in any way whatever." Thus, when Section 305 of the Code was amended to replace punishment of death with imprisonment with hard labour for life, Justice Lucan said that brought a child's conviction for murder squarely within the terms of Section 24. Justice Lucan makes several pointed observations about the Crown's argument and his learned colleagues' acceptance of it. He writes that any argument that, quote, Section 24 was somehow impliedly abrogated or altered or modified or made inapplicable by the amendment to Section 305 ignores well-established, well-recognised and sound principles of construction. Outside of courtrooms, representatives of the Labour Women's Vigilance Organisation took up the matter with local politicians in November 1922. They urged an alternative sentence than prison. The organisation felt it was its duty to enter a strong proposal and voice the indignation felt by its members at the sentence, arguing that no boy in a normal state would commit such a crime. They called for an amendment to the Criminal Code to ensure no child could again be subjected to such a sentence of imprisonment for life with hard labour. They called for the young boy to be returned to his community. They also objected to any child of 12 years old being taken from their community to work in the same circumstances that this child had been removed from his. Weeks later, on 11 December 1922, the High Court, in a few short paragraphs, unanimously adopted Justice Lucan's earlier interpretation of the law. The appeal was allowed. The matter was remitted back to the Court of Appeal to be dealt with according to law, consistently with the High Court's decision to endorse Justice Lucan's interpretation of Section 24. The boy thus had to receive an alternative form of punishment to imprisonment for life with hard labour. If we can go back to Section 24 then, the provision included a list of alternatives to imprisonment for children. Section 24B allowed for children to be detained in a reformatory or industrial school. 3 weeks later, on 30 December 1922, the Queensland Government made Palm Island, already designated a reserve and penal institution at that time, an industrial school under the State Children's Act for the purpose of incarcerating this young boy. The husband of the deceased received his wife's estate valued at £450, which I think would be around $20,000 today, and appears to have travelled to England to visit his mother. The boy would become one of 3 young Aboriginal men to defend Palm Island in 1933 against the violent killing spree of the Superintendent, Robert Curry. In closing, I am sure many of you are in the thick of dealing with juvenile justice issues on a daily basis. I hope that this presentation has given you some insight into the legacy of contemporary debates and what has informed the work you do now for centuries beforehand. The path to the legal and procedural innovation that was the Children's Court was led by a strong desire to accommodate developmental stage of childhood in the criminal justice system and a willingness to recast the law in a more merciful light in order to do so. The vision of these courts, however, immediately gave way to pragmatism and politics. In many respects, things have improved dramatically. We no longer execute children or sentence them to transportation for stealing apples. Children's courts continue to be vital parts of our justice systems around the country. But some things that campaigners fought so hard against over a century ago remain. The reasons why children commit crime, children being held in watchhouses, debates over the closure of children's court matters, and adult time for adult crime. All of these, with the addition of the disproportionate representation of First Nations children in detention, represent ongoing challenges for the juvenile justice system. In 2013, Alan Borowski, leading the first national review of these courts, described them as, quote, a natural social laboratory of experimentation and comparison. Comparing the grand vision for the first children's courts to the acts as passed tells us much about the social, political and legal attitudes towards children and juvenile delinquency. Indeed, Victoria's 1906 Children's Court Handbook noted that the work of the court would be akin to, quote, pioneers in some newly discovered country who must, to a large extent, rely on their own resources. Today we have over a century of resources, of research and experience that can be relied on to inform modern approaches to juvenile crime. There is now overwhelming evidence of what reformers in the 19th and 20th centuries suspected or speculated on. But significantly, they were prepared to act on that level of knowledge. We have so much more knowledge and experience today. I wanted to end this lecture on a somewhat positive note. This is hard to do, given the topic. I'm going to end, though, with a quote by a child welfare scholar and advocate here in Australia, Dorothy Scott, who has articulated this idea far better than I could. Reform happens when people have a dream which leads them to do the job in a different way. That's what the reformers of yesterday did as they faced their reality. They did it with a dream of how it could be different. That too is our task as we face the complex challenges of today's reality. Thank you.
Thanks, Robyn, for that lecture. I feel so much, I don't know if I'm uplifted or depressed, but I feel better informed in any case about the evolution of our laws in relation to youth justice. It's, as I say, a little concerning that the early objectives of the Children's Court legislation all seem to have been put aside by the laws we're currently operating under, except for perhaps the fact that even though I'm not 50 and I'm not a widower, I am sort of a little old lady that does this court, so perhaps that part might be partly fulfilled at the moment in any case. Can I ask you all to thank Robyn again for the research that's been put into that paper, because I've learnt many things tonight from that. Thank you very much. And this is a little goodie bag, I'm told. I don't know what's in it, but thank you again.
Thank you.
And there's refreshments and food outside, ladies and gentlemen. Thank you.